several other more special topics. You also talked about ethics and the legal profession, access to justice, global standards of legal education and human rights. And you came together to an international conference of jurists on rule of law. Liberty, democracy, and the rule of law, the Holy Trinity, must be protected and defended by lawyers and the judiciary all over the world. Thereby, we are more or less successful. However, to ensure the separation of powers and the rule of law are characteristic and basic elements of modern states, we need judicial independence. Judicial independence is an expression as well as a prerequisite for the separation of powers. Besides, judicial independence is a fundamental guarantee for a fair trial in respect of human rights. The United Nations Convention for the Protection of Human Rights and Fundamental Freedom, as well as the European Convention for the Protection of Human Rights, provide that everyone is entitled to a fair public hearing within a reasonable time by an independent and impartial tribunal established by law. Judicial independence is necessary in relation to the executive, especially to government administration and to the legislature. This requires institutional separation of judiciary from the other powers. Therefore, a judge is subject only to the law. In addition to this, each judge has personal judicial independence as well as in relation to his office. Personal independence demands that the judge is removable from his office only under certain conditions by law. Of course, these principles are also valid in case of the judges serving at constitutional courts and supreme courts established to protect the Constitution. And I think it is obvious that the judicial independence is extremely violated if judges are put under house arrest or if they are removed from their office on the conditions not ruled by law. I hope the events happening in these days in the neighborhood of India will come to a good and soon end. I think we all are convinced that judicial independence is neither a prerogative nor a privilege for the judges, but is in the interest of the rule of law and of people seeking and expecting justice. I thank you all for your patience and your attention. Thank you.
Thanks, my lord. Now, I am happy to invite Honorable Mr. Justice Narayan Roy, the Acting Chief Justice of Patna High Court, to address us on this occasion.
Respected Chairperson, foreign dignitaries of judicial fraternity, ladies and gentlemen. You see, I must be clear to say that I have come here to perceive things out of the deliberations held in the conference and to observe also so that I may apply the same in the judicial system and dispensation of justice. The topic which is being canvassed, in my view, is a bit controversial, and being a member of the judicial fraternity as a judge, I need not comment much on that. But I will say the relationship of bar and bench is reciprocal, and it is always conducive and docile, and it depends on the attitude of both sides. It much depends on us, it also depends on the lawyers. Now lastly, I will say that the young generations which are coming in the legal profession, they need a bit training and also some sort of impetus, either by the Bar Council of India, a state bar council, or by the state government. They are the most requirement, so that they may survive, they may stand, and they may continue to be as a lawyer. With these things, I thank you all.
Thank you, my lord. Now I will request Mr. Nosad Ahmed Khan, the President of Supreme Court Young Lawyers Association.
Good morning, everybody. Thank you very much, Mr. Adish Agarwalji, the founder chairman of the All India Bar Association and International Council of Jurists and Indian Council of Jurists. Indeed, it's really a matter of pleasure for we all youngsters who in fact joined this wonderful gathering for 2 days. And in fact, I can say with full enthusiasm that with dissemination of this knowledge and free interaction with lots of people, particularly judicial part, judges, executives, lots of lawyers from other different countries, other dignitaries from foreign countries, foreign delegations, all these delegates from foreign countries. So this free interaction with we all people, with most particularly to the youngsters, will definitely help us, and this will definitely help in future making as well as for prevailing rule of law. Thank you, sir, so much.
Thank you. Now I will request Honorable Mr. Justice K.N. Saikia, who has been the Judge of the Supreme Court of India, who has been the Judge of Assam High Court, and also Chief Justice in the High Court, and he has been the chairman of many national commissions to enlighten us in this valedictory function.
Honorable Chairman of this function, Honorable most esteemed judges of different countries, members of the judiciary and bar from different parts of the country. In this valedictory function, after full deliberations on the subject of rule of law, having retired quite some time back from the Supreme Court, I have not been able to keep abreast of the developments in jurisprudence and the legal systems in different parts of the country. Even so, when my friend Sri Adish Agarwal has requested me to speak a few words, I would expect that I would be excused for any errors of omission and commission that I am very likely to commit.
Commission, you always say, my lord, because you are always chairing the commissions.
Now, so far as the topic of rule of law in all its aspects, including as distinguished from rule of discretion, and what presently is the problem before us is the rule of terror. And a scientific analysis of this problem awaits the world, and we all hope that the law that has been serving the human society from time to time will be able to find out the roots of the tendency for rule by terror or rule by discretion or dictatorship. We all know that there has been serious efforts by different jurists to find out the correct path of legislation and the judiciary. Even Alpian said that jurisprudence is the knowledge of things human and divine, the science of the just and the unjust. We wondered why an authority, a jurist like Alpian said, knowledge of things human and divine. Now, with the progress of the 21st century, we are realizing more and more that there is something from the divine to be known, to be analyzed, to be studied, and to be utilized for the benefit of mankind. Recently, we have developed these cyber crimes and analysis of those crimes and so many things concerning the ether and the great wide above us. And perhaps Alpian could know at that time that things divine are also to be studied in jurisprudence as things mundane or on earth. We also remember what is the consequence of the failure of the legal system to the society. And we were told by Manu that it is law that holds the society together. Niti kilo nadi tira taruvat. The law is like the tree standing on the river bank and protecting it from erosion. And so Manu said, law is the protector of the society. And if law is destroyed, society is destroyed. Dharma eva hatu hanti, dharma rakshati rakshita. Dharma is there, religion is there to protect the society. And if dharma, that is law, is destroyed, the society is destroyed. And he also warned, or rather cautioned, that if dharma is lost, then the society is lost. Therefore, don't try to destroy the dharma by thereby destroying